Uh, Greetings, myself Kushagra Singh from BCom LLB, and today I am going to present the topic Marzul Maut, the deathbed gift. So now let's start. So first, we are going to give the introduction of our topic, the Marzul Maut. In India, the citizens are allowed to follow their personal law. So the Muslims of our country, they follow Sharia, the Muslim personal law, which is an Islamic religious law which governs their religious matter and their day-to-day life. The source of Sharia are the Quran, the Sunnah, Ijam, and Qiyas. In their personal law, every aspect of the life is listed as to make their life easier. One such aspect of their personal law is that the Marzul Maut, which simply means the deathbed gift. Now moving forward, the Marzul Maut transfer combined element of both gift, that is hiba, and will, that is wasiyat, but differs from both. These transfers occur when there is a genuine apprehension of death in the transferor's mind, that is donor. If a seriously ill person makes a gift during such time, it is considered a deathbed gift under Marzul Maut. Such gift follows a general rules of Shariat law and are valid only if the transferor died after making the gift. Now moving forward, so first, before understanding the Marzul Maut, we need to understand some basic element of hiba, that is gift, to make the better understanding of Marzul Maut. There are three essentials of hiba, that is declaration of gift by donor, that is ijab, in which the donor must make a clear and ambiguous declaration that he want to give the gift. He want to give the gift to the donee. The declaration can be oral or written, provided it explicitly states the intention of transfer of ownership of the property to the donee. The absence of clear declaration can render the gift invalid. Now, the second essential is acceptance by the donee, that is kubul. The donee must accept the gift, either explicitly or implicitly. Acceptance signifies the donee's consent to receive the property, completing the transaction. Without acceptance, the gift remains incomplete and unenforceable. Now, the third and most important part is delivery of possession, that is qabza. The gift is only actually complete after the actual physical delivery of the possessor. The delivery is one of the most important conditions of the gift, and the delivery should be complete whether if the property is movable or immovable. Now, by understanding it in the Marzul Maut case, the seriously ill patient who has the apprehension of death, in the apprehension can make the declaration of gift, and the person the person to whom he is making the declaration, which is donee, accepts the gift, and then after the delivery of possession, the gift is complete. Now we also need to understand the essential of will, that is wasiyat, as the Marzul Maut is the combination of both will and gift. Now, one of the most important limitation that Marzul Maut carry is limitation of the value of gift. The value of the property gifted under Marzul Maut should not exceed the 1/3 of the donor's total estate. Unless all legal heirs consent, the limitation aligns with the principle of wasiyat and ensure the rights of the heirs are protected. In the absence of such consent, the gift is valid only to the extent of 1/3 of the estate. So this is one of the conditions which is there in the will in Muslim law, that the person who is making the will cannot give one person more than 1/3 of this total estate, and this condition is applied in the Marzul Maut. Now, In apprehension of death, there must be genuine apprehension of death of the donor. तो जो भी डोनर है उसको अपने दिमाग में एक एप्रीहेंशन और एक जेन्युइन एप्रीहेंशन ऑफ डेथ होना चाहिए कि उसकी डेथ होने वाली है, और इसके लिए कुछ एक्सटर्नल इंडिका भी होता है, जैसे कि कोई आदमी जिसको कोई एक पर्टिकुलर जानलेवा बीमारी है जिसमें उसकी मौत इमीडिएटली हो सकती है, तो उस कंडीशन में अगर वो मर्जुल मौत करता है तो वो वैलिड होगा. द इलनेस ऑफ सच नेचर दैट इनकैपेसिटेट द डोनर टू डू हिज ऑर्डिनरी एवोकेशन. उसकी इलनेस ऐसी होगी कि वो जो भी अपने ऑर्डिनरी टास्क हैं वो नहीं कर पाएगा, या जो भी उसकी ऑर्डिनरी जॉब या जो भी वो नॉर्मल कंडीशन में करता है वो करने में कैपेबल नहीं रहेगा. और क्लियर डिक्लेरेशन ऑफ गिफ्ट बाय डोनर, कि जो डोनर है उसका क्लियर डिक्लेरेशन होना चाहिए गिफ्ट करने के लिए मर्जुल मौत में, कि वो किसी अलग प्रेशर से तो गिफ्ट नहीं कर रहा है, केवल एप्रीहेंशन ऑफ डेथ से ही गिफ्ट कर रहा है. डोनी का एक्सेप्टेंस होना चाहिए और डिलीवरी ऑफ पोजेशन होना चाहिए. अब एप्रीहेंशन ऑफ डेथ इन मर्जुल मौत, द गिफ्ट मस्ट बी मेड अंडर the apprehension of death. This is one of the most important aspect of marzul maut, because ki marzul maut it depends upon the apprehension of death of the donor. In marzul maut, the gift must be made under the pressure of the donor's genuine apprehension of imminent death due to the serious illness. The key factor is that the apprehension of death is only required in the mind of the donor, not the people attending to it. If the donor genuinely believes the death is imminent, the gift made during this time is considered valid, regardless of whether the donor is confined to a bed. तो अब इस पैराग्राफ का मतलब ये हुआ कि मर्जुल मौत में ये जो भी गिफ्ट किया जाता है वो डोनर के दिमाग में जो प्रेशर बना रहता है कि उसकी डेथ हो सकती है और इमिनेंट डेथ हो सकती है क्योंकि उसको एक सीरियस इलनेस हो रखी है, तो केवल उसी से, तो केवल वो जो प्रेशर है अगर वो केवल डोनर के दिमाग में बना है तभी एप्रीहेंशन ऑफ डेथ होगी. अगर कोई और, जैसे जो आदमी डोनर के साथ वहां पे है, अगर वो कह रहा है कि आपकी डेथ हो सकती है, तब वैलिड नहीं होगा जब तक डोनर को रियलाइज ना हो कि उसकी उस बीमारी से डेथ हो सकती है. However, if the illness persists for more than a year without worsening, it will no longer be considered a fatal illness, and any gift made during this time is not treated as a deathbed gift. If the condition worsens and leads to the death within a year, the illness is treated as new, fatal, and a gift made during this worsened period is valid under marzul maut. This is based on the understanding that if the illness remains the same for over a year without aggravation, there is no genuine apprehension of death. On the other hand, if the condition aggravates suddenly, making the donor believe the death is near, the illness considered a new one, and the gift can be considered a valid under marzul maut. तो इस पैराग्राफ का मतलब ये हुआ कि अगर कोई आदमी है जिसको एक सीरियस इलनेस है, लेकिन वो इलनेस साल भर से ज्यादा हो गया है और उसकी डेथ नहीं हुई है, तब उस इलनेस को मर्जुल मौत नहीं माना जाएगा, क्योंकि साल भर से ज्यादा हो गया है, उसकी कंडीशन बिगड़ी भी नहीं है, या तो स्टिल है या तो शायद रिकवर भी किया है. तब तो गिफ्ट अगर उसमें बनाएंगे तब उसको मर्जुल मौत नहीं माना जाएगा. लेकिन अगर साल भर से ऊपर हो गया है और उसकी कंडीशन और बेकार हो गई है और खराब हो गई है और तब जाके उसकी डेथ होती है, तब उसको मर्जुल मौत माना जाएगा, क्योंकि तब उस डिजीज को न्यू डिजीज बोला जाएगा और उसको फिर मर्जुल मौत माना जाएगा. नाउ मूविंग फॉरवर्ड, इन द केस ऑफ शलक नुरबी वर्सेस पठान मस्तानबाई एंड अदर्स, इट वाज सेड by the court that there are three conditions which have to be satisfied for the transfer to be considered as marzul maut. These conditions are the proximate danger of death which cause the apprehension of death in the donor's mind, a certain degree of subjective apprehension of death in the mind of a sick person, that is donor, some external indica that person's inability to attain his ordinary avocation. In case of Mumtaz Ahmad versus Wasi-un-Nisa, it was held that the doctrine of Marzul Maut will only apply in the cases where the gift is made under the imminent pressure of the death. इसका मतलब ये हुआ कि इस केस में ये बोला गया था कि मर्जुल मौत का गिफ्ट तभी अप्लाई होगा जब वो डोनर बनाएगा अंडर द इमिनेंट प्रेशर ऑफ डेथ. अगर कोई उसको इमिनेंट प्रेशर ऑफ डेथ नहीं है, एप्रीहेंशन ऑफ डेथ नहीं है, तब वो मर्जुल मौत में गिफ्ट नहीं होगा. अब नाउ मूविंग फॉरवर्ड, डिफरेंस बिटवीन मर्जुल मौत एंड डोनेशन मोटिस कॉजा. The donatio mortis causa governed by the Indian Succession Act 1925, and in that section 191 deals with the deathbed gift, whereas Marzul Maut is governed by Muslim personal law. Under Indian Succession Act, only movable property can be disposed by the donatio mortis causa, whereas in Marzul Maut the property can be either movable and immovable. In donatio mortis causa, no terms are laid down as to which the property can be disposed, how much and to whom. But in the case of Marzul Maut, the gift is subject to limitation and only 1/3 of the property can be disposed. In case of donatio mortis causa, the gift will become invalid when the donor recovers. But in case of Marzul Maut, the proceeding of hiba will take place if the donors recover. Now, moving forward to the some of the leading cases in Marzul Maut, like Sheikh Nurbi versus Pathan Mastan Bhai. This is one of the leading case which we have discussed above. But but now I tell you in the brief. In this case, Andhra Pradesh High Court emphasized that the gift to qualify as Marzul Maut, 3 conditions must be met, like proximity of danger, subjective apprehension of death in donor's mind, external indica. And now to the next case, Abdul Hafiz Beg versus Sebi. In this case, the Bombay High Court examined whether the gift made by Abdul Qadar during his terminal illness was valid under Marzul Maut. The court highlighted the importance of establishing the donor's apprehension of death and the delivery of possession for the donee. The court upheld the gift, nothing that the donor's conditions and action met the criteria of the Marzul Maut. Like in this case, the donor's condition and criteria met the criteria of the Marzul Maut, and so that is why the Bombay High Court upheld the gift. Now Fatima Bibi versus Ahmad Baksh. This is the Calcutta High Court case. In this case, identified 3 essential conditions for valid Marzul Maut gift: illness that caused the donor's death, apprehension of death in the mind of donor, external indica such as inability to perform his ordinary task. The court decision laid the foundation of the understanding the requirements of the Marzul Maut in Islamic law. Now, the Commissioner of Gift Tax versus Abdul Karim Muhammad. In the Supreme Court of India upheld the exemption of gift made under Marzul Maut from the gift tax. The donor seriously ill and fearing imminent death gifted movable property to his relative and died within 6 weeks of executing the deed. Despite the gift tax officer assessing the gift as taxable, the court ruled that it was valid under Marzul Maut as the donor's serious illness and apprehension of imminent death was key factor. The court referred the section 191 of Indian Succession Act and emphasized that such gifts made in contemplation of death are exempted from the gift tax. This decision clarified the special legal statute of deathbed gift in Islamic law. Thank you.